Hello and welcome back to my channel, US Visa Journey. Today I want to talk about a topic we're getting a lot of phone calls about here in my office. That is, you have a family member who is detained by immigration authorities while they fight their case in front of the immigration court. In the past, the immigration judge would consider a bond request, decide whether or not the alien was a flight risk or a danger to the community, and as long as they were not, they would be released on bond in most cases and be allowed to fight their case while they were home with their family. Well, that all changed in September of 2025. The Board of Immigration Appeals, the BIA, decided that any alien who had not been admitted in some fashion, for example as a tourist or as a student or some other legal way, even if they had lived here for 30 or 40 years, were not eligible to request a bond from the immigration court. At that point, the immigration judges did not have jurisdiction to release any alien on bond who fell into that category. There was a class action lawsuit filed in the Central District of California in the federal court, that's Los Angeles, and that court issued an injunction requiring the immigration courts to consider that group of aliens for a bond. However, a few months later, the chief immigration judge sent guidance to the immigration courts throughout the country and stated that the BIA case was controlling and that any aliens who had not been admitted would not be allowed to be released on bond. There was a few changes back and forth in the following months. However, as of January 13th, it looks like most immigration judges are finding they do not have any jurisdiction to even consider a bond for this class of people. So what do you do if you have a family member who is in custody and they are fighting their case and they want to keep fighting their case, but you obviously want them home with you? Well, what we do is we file a petition for a writ of habeas corpus. Now, habeas corpus is a writ that goes back over 1,000 years and literally means in Latin, you shall have the body or produce the body. Basically what it boils down to is that the government cannot detain someone unlawfully without due process of law. In this case, what it means is we file a petition with the local federal district court that has jurisdiction over the detention center where the alien is detained. In that petition, we ask the court to do one of two things. We ask them to either send an order to the immigration court compelling that court to conduct a bond hearing, and if the alien is not found to be a danger to the community or a flight risk, they need to be released on a bond. The other order the federal court can make is an order compelling the government to release that person from detention immediately. It's a very complicated process, and as I said, we're receiving a lot of phone calls about this because there's a lot of confusion as to what the law is. So if you have a family member who has had a bond hearing and has been denied, or your immigration attorney is telling you that they are not eligible, please contact us at usvisajourney.com to schedule a consultation, and we will review whether a petition for a writ of habeas corpus is appropriate for your family member. Again, like and subscribe, and visit us at usvisajourney.com. And please follow us on social media as well. Thank you.